So we've recently had the long-awaited and highly anticipated decision in Thatcher's v Aldi, which concerned a copycat packaging for a lemon cloudy cider product. Thatcher's lemon cloudy cider had registered a trademark in respect of the get-up or packaging in which their can was sold, and Aldi had produced a fairly similar looking product which it was selling it within its supermarkets. The case is interesting because it's one of the first in which a court has looked at whether trademark infringement, and in particular unfair advantage, can be taken as a ground against copycat packaging. So the two products, when compared side by side by the judge, had similarities and dissimilarities. However, the judge in this case felt that the dominant element of the marks was very much the Thatcher's name on the one hand, and the Taurus name and bull device on the Aldi product. They were considered to be dissimilar. To the extent there were similarities, that would be around the use of leaves and lemons, which were somewhat commonplace for lemon-based products. So based on that, and taking into account that there was no evidence of actual confusion, the judge wasn't prepared to find that there was a likelihood of confusion or trademark infringement. But looking at unfair advantage, the judge held that there was a bringing to mind when you looked at the Aldi product, but it wasn't enough for trademark infringement in that sense, because there was no intent to take unfair advantage, or indeed there was no detriment to the Thatcher's product. And in particular, the judge actually tasted both products and held that whilst someone might dislike the Aldi product, that doesn't necessarily mean it'd be detrimental to the Thatcher's product by way of association. So there was no unfair advantage in that sense. For similar reasons, there was no misrepresentation for consumers for the passing off ground, and that also failed. So what are the lessons from the case? Well, it's still difficult to decipher how a judge may decide any particular case. That case may be appealed, but the advice for brand owners at the moment is that they should still seek to register trademarks in respect of packaging and get-up so that they can take appropriate cases that may be decided by a different judge on a different day and enforcing their rights in how their products look.